According to the court, the applicant is not a party in the original case and wanted counsel for the applicant, Atta Akyea, to properly come to the court by citing the relevant authorities that he was relying on. The court further directed parties in the case to come for the details to the ruling in October when the court returns from the legal holiday. Abu Ramadan, the applicant to the case, in an interview said he was disappointed with the ruling. He stated that the court should have given him time to properly prepare and appear again. He said even though the court in its own submission agreed that the case was a novelty one which they had interest in, they did not give him the opportunity to make the necessary changes.
Respondents in the matter felt that we didn't have capacity to come before the court since we're not parties to the issue. Lawyers argued out, the bench or the judges give a cue that they felt it was a novelty and they had an interest in the matter. And for that matter, my counsel should try and go back and cite more authorities and to back his already good case he's putting before the courts so that they are more convinced. But upon that advice, we applied for an application for adjournment to give us time to go and cite to those authorities and come back. It is unfortunate for our country. That's what I'll say.
The legal representative of the applicant, Atta Akyea, also expressed disappointment to the ruling, claiming the Attorney General, who had jurisdictional powers of defending the Constitution, had not shown interest in the case.
Supposing that the Attorney General will come. The Attorney General did not file one paper. So are we saying that Ghanaians should fold their hands if the Attorney General doesn't want to work and defend the Constitution? Another Ghanaian cannot do it. Is the defense of the Constitution the sole preserve of the Attorney General? That would be a very unfortunate conclusion to come to. But that's what the law...
Bernard Mona, who had initially challenged the legalities of the CI-75 that sought to get the court work on holidays, said the case has been a waste of time and felt the court should not even waste time to hear the case.
We know that we have the truth and we know that at all costs we are going to win. Because we came here on a meritorious case, and therefore, as I keep saying, truth stands. It doesn't matter how much you push it, you dip it. It's like a cork. You put it in the water, it will certainly spring up. In this particular case, they wasted our time. The basis for which they even came to court was what the court questioned. That you don't have a basis, you don't have the capacity to come to court. You don't have the local standby to be in court on a matter of this nature. And we were praying that the court will grant us opportunity to seek cost on them. Because